Hi, this is Ty Hyderali. I'm a plaintiff's lawyer. We concentrate in employment law in New Jersey and New York. So April 30th, 2021 was a very good day for employees in the state of New Jersey. The appellate court decided a case in the case of Hampton versus ADT. And Mr. Hampton was an employee who worked for ADT, and Mr. Hampton executed an agreement while he worked at ADT that if he had any causes of action, any claims against ADT that arose out of his employment, they would be subjected to mandatory arbitration, which is kind of a hot button item right now in the world of employment litigation. And despite that, Mr. Hampton decided when he had claims pursuant to a statute called SEPA, the Conscientious Employee Protection Act, which is a whistleblower statute with very important protections under it, he decided to bring it into in litigation. And ADT said, well, hold on a second, we have this arbitration agreement, and moved to compel arbitration and bounce it out of litigation. And why do companies want to do that in certain cases? Well, number one, the biggest reason is it deprives an employee access to a trial by jury, which is a very important right that they are giving up when they sign these agreements that have these mandatory arbitration clauses. And we always counsel our clients to be careful in signing these offer letters or employment agreements that have mandatory arbitration agreements, because it really does strip you from important rights that you may otherwise have. In any case, ADT moved to compel arbitration, and Mr. Hampton said, wait a second, not so fast. ADT, you never signed the arbitration agreement. Maybe I did, but you didn't. Therefore, the arbitration agreement is not enforceable. And luckily, the New Jersey Appellate Court said, good point. The only way you can have a meeting of the minds in an enforceable arbitration agreement is if both parties sign the agreement. Because the court said otherwise what can happen is ADT can choose and pick and say, well, we want to enforce arbitration here. Here we didn't sign the arbitration agreement, so we don't want to enforce arbitration agreement there. And that's simply inequitable, and therefore is void against public policy, and it's not going to fly. The court also had some other really interesting rulings. The court said, well, also, by the way, ADT, you tried to slip in this clause in the arbitration agreement that said the costs of arbitration are split 50-50 between the employee and the employer. The court said, not so fast. That's unconscionable, because to file claims in arbitration is very expensive, and most employees can't afford them. So what the courts have ruled is that, well, listen, employer, if you're going to want to force employees to litigate their cases in arbitration, well, then you're paying the cost of arbitration, which is very fair. Here, ADT tried to kind of slip a fast one in there and say, we'll split it 50-50. Court said, nope, that's not enforceable. And also the court said, furthermore, there's some language in the agreement that seemed to deprive Mr. Hampton, if he won his SEPA claim, of getting attorney's fees and costs, which is recoverable under the statute. And the court to that also said, not so fast, ADT. That clause, too, is unenforceable. If Mr. Hampton lights you up in arbitration or litigation, here it seems to be litigation, and he wins, you're paying his legal fees and costs. So a very good victory for employees in the state of New Jersey. This is Ty Hyderali. Be safe and be well.